Welcome back to Wealth Watch. I guess we're officially off our summer hiatus. Everybody's back from summer vacation, and hopefully life has gotten a little bit more back to normal for you since we last talked. As we dive back in today, we wanted to cover the estate planning and the estate settlement process. We get a lot of questions from our clients related to fears and misconceptions that kind of surround that. It can be a little murky for people, and it can also create some anxiety for people. So we wanted to take time today to hopefully, assuage some of those fears and maybe unlock a little of the mystery surrounding that process from top to bottom. So joining us today, we've got three of my coworkers who deal a lot in this space and are experts for us, who are going to share some of the pieces and some of the information around it. Katy Neyhouse, Shelley Bigelow, and Alan White. They're going to join us this morning and cover some specific topics that are touch points throughout the planning and settlement process, like I mentioned. So good morning, guys.
Good morning.
Good morning, Clint.
And so to kick us off, Katy, I'd like you to maybe talk a little bit about some of the early stages. And one of the keys in this is naming an executor for your estate. So if you would, maybe talk a little bit about what that person or what those people do, and why it is sometimes a good idea to maybe not name a family member, an acquaintance, or a grouping of those, some of the problems that can cause.
Sure. So in your will, you list an executor, and the executor is the person who handles your affairs, who takes care of the property that you own, and just follows the terms of the will to just take care of everything that you own, whether it be a house, checking accounts, that type thing. A lot of people list an individual as an executor, but I'm going to go kind of through some kind of thought points on why maybe you should list a corporate executor. And so instead of listing an individual, say, like a son, a daughter, a sibling, a spouse, or multiple people as executor, you can name a corporate executor. So for example, you can name Farmers National Bank as executor in your will. And there are many benefits to having a corporate executor, so I'm going to talk about just a few of those. One thing is location and time commitment. Does your executor live near you? Your estate has to be settled in the county in which you reside, and it can be difficult to settle an estate if the executor doesn't live in that area. So acting as executor requires a significant amount of time. So if this is going to be a burden to someone, then a corporate executor would be a good option. Another thing to consider, family disputes. Is there the potential for disputes within your family or among beneficiaries? So corporate executor offers independent, non-biased, and professional approach when dealing with family members. So, like for example, there's a good chance that if two siblings are arguing about a set of dresser drawers, then it would be easier for the bank as executor to settle that argument than it would be for another family member to do so.
Hey, Katy, can I ask you a quick question?
Sure.
The majority of estates that you see, is family most often the first named executor before they explore the corporate executor route?
I think just in general, yes, that is. The wills that we see, they've given them to us because they've listed farmers as executor, but in general, people tend to list like their spouse or their children first.
Okay.
Yes. Sure. Another part to consider is expertise and knowledge. Does your executor have the required knowledge to make effective decisions? Because they need to be competent in dealing with matters related to estate and trust law, potential legal issues, taxation, investments and personal effects, and then even possibly real estate. So, in speaking of the personal effects, I'll name off some of the items that we as corporate executor have handled in estates. We've had household and personal items, coins, stamps, houses, vehicles, artwork, artifacts, jewelry, guns, horses. So we've handled a lot of different things that have given us expertise in that area that maybe just the general person wouldn't know, like a good contact or have the resources to talk with about and handling the estate.
So it's a fair statement to say, not only the expertise aspect, but kind of the, you mentioned like multiple siblings, taking the favoritism aspect out of it, the family dispute aspect out of it, just a number of different advantages to offload that to a corporate executor, it sounds like.
Yes.
Very good. Well, shifting gears a little bit, so we've named our executor now, and now, unfortunately, the executor has been engaged because now we are having to begin to settle the estate. One of the common things that I think we hear are misunderstandings and fears as it relates to probate, and the one that I'm familiar with is cost. It's exorbitant and it's this long drawn out process. So, Shelley, if you wouldn't mind, I know cost is one of them, but walk through some examples of misconceptions that people have about the probate process, some of the ways to either clear that up or to put things in place that help you to manage the probate process in a more efficient manner.
Okay. Well, I don't know how much people know about the process, so I thought I would go over that briefly. Probate's the process of proving your will in district court. That's where the executor is named. Once the executor is sworn in, they are charged to gather the assets, pay all the debts, distribute property in accordance with the will, and then provide a final accounting to the court. So there's a 6-month waiting period between being named as executor where creditors are able to come forward and say, I haven't been paid. That might be due to some work being done at the house, just some other bills that the executor may not know about. It gives that 6-month waiting period for creditors. Assets included in estate, as Katie mentioned, individually owned property, automobiles, investment accounts. When you have a joint tenants in common account, the decedent's part is also part of their estate. Safety deposit box contents, that sort of thing. Yes, expense is a huge factor in whether people want to go through probate. And part of that expense is the attorney fee, and it could be an executor fee if you do have a corporate executor. And it's my opinion that it shouldn't scare you about the fees. Some attorneys charge hourly, some charge a percentage of the estate. That fee for Kentucky won't go above 5%. There's a cap on it, but you're getting a lot when you have that fee. You're getting the comfort that they are familiar with state laws. They can walk the executor through the process. It's a little bit of oversight. Now, if the executor wants to do more on their own, then they can, and not have to rely on the attorney as much, the fee could be less. But if you have a straightforward estate, then the expense is not going to be that bad. If you do have a complex estate with a business to sell and real estate, yes, you may pay more in fees, but I think it's worth the oversight and making sure everything's done correctly, because there would be nothing worse than having to open up an estate years from now because of something that was not done properly. Another misconception is it takes years to go through probate, which is not true. The longest piece, as I mentioned, was the 6-month waiting period for creditors. I've had one estate that took 2.5 years because we were selling a pretty big piece of land. We had to subdivide it, but most estates, I would say, can be done in a year or less. After that 6-month waiting period, we're able to start making distributions if it's a average estate. And then after that, if it's a complex one where there's just more assets or just a larger estate, we may have tax returns that we have to wait on. But I would say a year is typical, with some distributions going out after the 6 months. And then if you have property, or as Katie mentioned, if you have disputes, that can definitely drag on the process. But the biggest thing is having the oversight for probate. It used to be that if you did not go through probate, creditors had 3 years to make a claim against the estate, which could be very problematic. They just changed that to 8 months. so that it does prolong it 2 months if you don't go through probate, but that's kind of a small thing. Two other things I kind of wanted to mention. Your will is public record, so anyone can look at it in the courthouse, and if you have concerns about that, an irrevocable trust or revocable trust might be a better option for you. Some people, when they do a trust, they still have a will. It just pours everything into the trust so that other people don't know who were beneficiaries. And then another thing that consideration is the pay on death or transfer on death accounts that Alan will talk about, I believe. Be careful when you try to do those to avoid probate, because if your will says you want everything divided by 3 children, and then maybe you have a child.
Okay, it looks like Shelley's video froze there. Alan, are you still with us?
Yes.
Okay, very good. I tell you what, I did get a question while we were going there, and so Katy and Alan, I'm going to throw this one out to you, and if not, we'll be sure to circle back around and answer this at a later time. But Shelley had mentioned that creditors have 3 years to bring claims against an estate. She also mentioned disputes. Internal disputes are at times cause for the probate process to linger. Is there a limitation from a time standpoint on how far out a dispute can come?
I don't believe there's a statute of limitations on a dispute of sorts. There's a legal proceeding that has to go through the courts, that type of thing. I don't believe that there is a statute on that. But however, you mentioned about it's a 6-month waiting period, typically from the date that the executor is appointed for creditors to file claims in a will that's probated. So it wouldn't be any much longer than that at all if the will is going to probate. So it's in that case, yes, there is a time limit. If if there are legal lawsuits, things of that nature that arise, then that may stretch that out certainly longer. But under the normal circumstances of a will, if it's probated properly, that 6-month time frame is there for the creditors to file claims.
Very good. And it looks like we got Shelley back now.
Yes.
Technical glitches are certainly a staple of our Wealth Watch. So Shelley, if you would just pick up, you had finished talking about the will being public record. And so if you would just pick up there.
Okay, yes. So I was saying it's public record. If you wanted more privacy, you can obviously use the irrevocable trust or irrevocable trust. I was then starting to touch on pay on death and transfer on death accounts. Some people try to do those to avoid probate, which in smaller estates you can. But one thing I'm always concerned about is if someone has put in their will that they want 3 children to get things equitably, but then maybe later on they have a child taking care of them, so they have a joint account and they do a pay on death, that child may end up getting more than the others, or it may mess up what they put in their will. So that's just something to consider when trying to avoid probate. You just want to make sure everything's in sync with your will.
Very good. Thanks for the quick turnaround on jumping back on as well. We appreciate that.
You're welcome.
And so, shifting gears to the last piece that we wanted to talk about. Well, before I go on, I did want to point out Alan, who I just pulled up on the screen a minute ago. He's not quarantined. He's not unpopular. He's just adhering to good social distancing. That's why he's in that giant conference room by himself. But Alan, when it comes to estate settlement, often you'll hear people make a statement around, I've got a will in place, so that takes care of everything, or I went through and designated beneficiaries on my assets, even though I don't have a will, and that should take care of everything. If you would, just provide some color around how specific assets have different treatments when we start to settle estates.
Sure, Clint. beneficiaries, are named in a will, and they will receive either specific assets, they'll receive a percentage of the value of the estate that's probated, or set amounts that are dictated in the will. And I think from that standpoint, it's necessary that through the years, if you have a will, to make sure that you revisit that and make sure that that's the way you want that carried out. Because if something happens to you, you pass away, the terms of that will, that's going to rule the day when that estate is probated. There are other ways beneficiaries receive assets when someone passes away, and that's under, where they're named directly, say on retirement accounts, either IRAs, traditional or Roth, 401k plans, 403b plans, life insurance proceeds, annuities. All of those accounts offer you the ability to name a direct beneficiary of those. So when you pass away, that money or that percentage or those assets will pass directly to the beneficiaries named in those accounts. Now, the interesting thing about that is that if that's the case, that you have named someone in, as a beneficiary of your IRA, that person is going to get that IRA upon your death, regardless of what your will might say. So I think it's very important that you make sure that you're reviewing your will, but you're also reviewing your beneficiaries on those direct beneficiary accounts, such as retirement accounts, life insurance, annuities, things like that, and make sure that they're in sync with what you want to have to happen. The other thing that I will say, we talked a little bit about named beneficiaries of those various accounts. There are a couple of different terms of those beneficiaries that you want to be aware of. A per capita beneficiary, basically what that means is, let's say you've got an IRA and you've got 3 children, you name those 3 children as primary beneficiaries of your IRA per capita. What will happen is, if one of those children predecease you, their share will be spread amongst the other 2 that are still living. It does not follow down their family tree to maybe their children. So that's called per stirpes. If your beneficiaries are named per stirpes, it kind of follows a generational distribution. In other words, those 3 children that were named in that one policy, if it's per stirpes, one child predeceases you, you pass away, their share will flow on down through to their children. So it's very important that you look at that and make sure that that's the way you want that to go. And that's kind of a common mistake. We try to talk about that when we're talking about beneficiaries on various accounts. Per capita shared equally amongst the beneficiaries if one of them passes away, and the other per stirpes, it follows down that family tree if one of those named beneficiaries predeceases you. There are other designations, and I think Shelley mentioned POD and TOD. POD is pay on death. A TOD is transfer on death. The pay on death typically refers to bank accounts, checking accounts, savings accounts, things of that nature. Your transfer on death typically relates to investment accounts, stocks, bonds, mutual funds, things of that nature. And if you name someone as a transfer on death beneficiary and you pass away, it's just like an IRA. It's going to go to that named transfer on death beneficiary, regardless of what your will might say. So you have to be very careful about that. I think the important thing really is to just make sure that you're reviewing your will, you're reviewing your beneficiaries on those direct named beneficiary accounts, and make sure that that's all in sync. and make sure that that's the way you want it. You know, the biggest fear that a lot of people have is, okay, we have a lot of blended families these days. We may have an ex-spouse remain named on a IRA, and you don't revisit that beneficiary designation. You pass away, you know, that money's going to go to that ex-spouse, and that could cause, and probably would cause some problems for you.
Hey, Alan, do we have any tools that we use, or are there online tools out there to help guide people, or maybe steer them in terms of what are beneficiary assets and what are more will assets?
Well, yeah, I think really the ones that we mentioned basically are, you know, your retirement accounts, anything where you're able to name a beneficiary for that specific account, like a life insurance policy, an annuity, retirement account, even the TOD, POD accounts on regular investment accounts as well. You know, that if something happens to you, whoever you've named as beneficiaries under those accounts are going to receive those assets regardless of what your will says. I don't know if there's any online information or any tools or what have you that we use, but when we're talking with people, you know, we're really requesting people think about this. And, you know, one of our first questions typically when we're talking to somebody, do you have a will? You know, if they don't have one, you need to get one, because the state of Kentucky has one for you, and you may or may not like it. And then the other question that we ask, when's the last time you looked at it? Because a lot of people get them. I mean, we've talked to people that haven't looked at their will for 20, 30, 25 years. And it's kind of, got to look at them. You got to revisit them.
So it's fair to say people really need to lean into professional expertise on some of these items. It's maybe not something you want to try to tackle on your own.
I think that's fair to say, yes.
So we've got a question that's come through another question that's come through while we've been going, and I'll throw this out to the group and you guys let me know who wants to take it. Can the bank serve as co-executor with a surviving spouse?
Shelley, you want to take that?
Sure. Yes, we can, and we have done that in the past. We've served as co-executor with a spouse, and also just co-executor with another. We had one, actually the estate that took 2.5 years, we were co-executor with another professional in town. So that is possible. And
can you maybe just briefly shed some light on how the responsibilities are shared in an instance like that?
Yes, we just do everything together. We make the decisions together. We usually, depending on how the will is stated, we may have to also sign off on everything, both of us versus one of us. But we just make all the decisions together, and they're just as involved. We may, as corporate executor, take a little more of a lead. But we definitely consult with. Ultimately,
all parties are signing off on everything.
Yes, we want everybody to be all on the same page and in agreement.
Very good. Very good. Well, I don't see any other questions. I would like to tell the person who sent this most recent question, as a Seinfeld fan, I'd greatly appreciate the screen name you used. But in case it's your actual name, I'm not going to use it. So that wraps us up on our topic today. Thanks everybody for joining. We're going to crank the Wealth Watch series back up now that summer's coming to an end, and we'll have some information out about the next one. If you do have topics you'd like us to cover, of course, please send those in. And also, as we've mentioned numerous times in the past, you can find today's video under our resources tab on the Wealth South website. Guys, anything you'd like to share in terms of if people have questions, who they should get in touch with, how they should get in touch with you, et cetera?
Well, I think
all of.
Yeah, go ahead.
I think of our information is on our website, wellsouth.com, but you can probably call anyone in the WellSouth group. We usually help look over people's estate plans. We're very willing to look at trust and wills and give suggestions. So we're happy to talk to anyone who would like some help.
Great. Well, thank you again, Katy, Shelley, and Alan, for your time today. Thanks for those in attendance, and we will see you next time on Wealth Watch. In the meantime, everybody stay safe. Take care.